Does that do anything?
Okay, I just did something and it said the session is being recorded.
Yeah, I see that.
I'm just going to say, can you hear us? Can you hear?
Liz, do you want to take control from me?
I mean, I can have control.
She can.
The only thing that you took control was to use the mouse to go through the slides.
Mm-hmm.
It's now recording.
I pushed something that said start recording, but it didn't say
That's just recording.
Yeah.
Okay, why does it say press 1 to start the broadcast?
Are you pushing it on the computer, the phone?
That was on the phone. Maybe I'll do it. Hold on.
Push it on the computer.
Nothing's happening. Nothing's happening when I push 1. I feel like that is what I'm supposed to do.
Do you have a cell phone number for Hunter?
Yeah.
I'm going to try texting him.
Yeah.
And Liz, maybe you should just put out something into the chat box because I think people are wondering.
Okay.
Just say technical difficulties.
We may have to reschedule, Heidi.
Okay.
I don't know how to.
Sorry, guys. I will.
That's okay. It's okay. I'm going to try something real quick.
Maybe Robert knows how.
Huh.
He does a webinar every month. I wonder if it's somehow how I phoned in, maybe? I have no idea. At the time of the webinar, click the orange start button on the scheduled webinar time. Start with reading the intro. I just don't see a start webinar on this stupid thing. So annoying.
So in the control panel, it shows start broadcast at the very top on the right-hand side. I can't see it in my version of the control panel because I don't have that control.
Ditto.
I don't know why I can't see that either. I'm going to take a picture.
Jennifer, it's probably because you and I are panelists.
Right.
Whereas,
So give Liz control back
yeah,
of everything.
Well, it.
I don't know.
Yeah, I've got this, and all it's saying is that I can take control. I can't figure out how to.
I think I took control back.
Yeah, you have. We both have control.
I don't know, but I can move my mouse. I can click on anything.
You have control back.
I just don't have the start button that they say I'm supposed to have. And I Don't know if it's because,
Okay, pressing *1. Try pressing *1 on your phone that you're using for audio.
okay, I'll try it.
The broadcast is now starting. All attendees are in listen-only mode.
Oh my gosh.
Oh
Hello.
my gosh, everyone. Thank you for your patience. Liz, go ahead.
Hi, yes, thank you. My name is Liz Gallagher. I'm a paralegal here at Lyles Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Buying and Selling Home Health and Hospice Agencies. Today's presenters are Jennifer Papapaniotou and Heidi Coker. And without further ado, I will pass it on to the presenters.
Well, good afternoon, all, and thank you all for your patience while we resolved our little set of difficulties here. I am going to very quickly advance the slide here, and so that we have a discussion, a table of contents, and what we're going on. Very briefly, I am a partner at Lyles Parker. Most of you know us. Jennifer is another one of our partners. Jennifer and I are both located here in Texas, and we do nothing but healthcare law. This is our bread and butter. We don't do anything else. So we have taken this webinar with our experiences over the last few years in handling purchasing and selling a home health and hospice agency, and have kind of distilled it down to what is now going to be a 45-minute webinar. We're going to move pretty quickly, I think, because there's a lot of material here. Please feel free to reach out to us afterwards. Our contact information is at the end of the presentation. So real briefly, we're going to talk about some trends. We're going to talk about transaction basics, some of the relevant healthcare laws. Of course, you guys know we're lawyers. We couldn't not talk about laws. Important steps and documents, post-closing issues, and then some special considerations for home health and hospice agencies. All right, so current trends. So one of the things that we're seeing is that wraps will be suppressed if you have an agency with a true CHOW. CHOW stands for change of ownership, and 100% share or owner member interest transfer if they've been certified before January 1st, 2019. So unless you're a brand new agency, this is probably going to apply to you when you do a sale. The other thing to know that the review choice demonstration is, of course, back in full force for Texas. It was paused due to the public health emergency, but the fact that you are in a review choice demonstration is going to impact any sales that you do and people who are doing due diligence. So you should be aware that this creates some background, some particular interesting backgrounds in the due diligence process. And the integrity auditors are still very, very active. Again, there was a pause while the public health emergency was sort of in the worst of it, but last fall they started up again and earlier in the year. And what has happened is all of those audits that should have been happening all along didn't, and so we're going through a log jam, a backlog of audits and investigations. So as a result of that, we're seeing a lot more suspensions and revocations of Medicare billing privileges along with overpayment demands. We also have a lot of criminal prosecutions for healthcare fraud, and this is the legacy of the Roy Jacques case. That case, he was convicted back in 2016 up here in the DFW area, but the shadow that casts over all of the prosecutions and investigations here in Texas is pretty long. So we're still seeing a lot of this, and again, potential investors, particularly private equity and venture capitalists, they're going to be aware of this, and these are some of the factors that they have in the backs of their minds as they're looking at home health agencies and hospices and going through the due diligence process. All right, moving right along. So let's talk very briefly about some transaction basics. So these transactions, particularly in the healthcare industry, can take months to complete. You know, can you do a sale in the space of 6 weeks? Yes. but I would not count on it. There's a lot of work that needs to be done up front, and the sale is actually only sort of the last piece, the culmination of a very long process. If you're thinking about selling your agency, you should be taking actions right now to get your house in order. You know, make sure that everything is ticked and tied, your documentation is accurate, all of those kinds of things. Do mini audits as well. That's why these things take so long. The other thing is these people who are out there purchasing agencies, they're not in a hurry necessarily. So they can absolutely take their time and find the right fit and the right agency that they want to buy. In the contrast, because of all of these increased costs and complexity and enforcement risks, what we're seeing is many owners are choosing to sell their companies. Hopefully nobody has to sell as a fire sale and get it done quickly. But I think this is another reason why we're seeing a lot of activity here in this space. The one thing that we would say, and this is not because Jennifer and I are lawyers, but because we have seen this over and over again, is you need to hire a lawyer in this process. Healthcare is really, truly subject to many laws and regulations, and the legal advice that you get, whether it be from us or from somebody else, is really going to help you in the long run and prevent you having a bad outcome on the back end with a violation of the law. I have had to deal with numerous issues where people have tried to do the do-it-yourself approach to selling a business and an entity, and 98 times out of 100, there's a problem and it requires a lawyer to clean it up, which means you're spending more money actually on the back end than if you had just done it right from the get-go. The other thing you may want to do is consider retaining an accountant or valuation expert to review and advise on the status of assets and entities. So most of the home health agencies do not have a whole lot in the way of hard assets, and Jennifer will talk about this a little bit. You don't have a lot of physical assets to sell. It's a lot of goodwill, and that can be very hard to value. A valuation expert can help with that. And the other thing is, if you have a valuation expert, they will come up with a fair market value that if something goes cattywampus or sideways in the long run will give you a good defense that the transaction was fair market value. So do your homework. Don't be afraid to walk away. There's actually a lot of people out there right now purchasing agencies, and if it's not a good fit and it's not a good sale for you, walk away. Somebody else will come. The other thing is that many deals that reach the letter of intent stage never close. The letter of intent basically just puts a pause on things and says you're not going to shop your agency elsewhere. And what happens is that they go through the due diligence process and something comes out in due diligence on either side that is not acceptable. And so the transaction doesn't proceed. And, you know, maybe somebody just has a change of heart. The other thing is that every deal is different based on the unique scenario each buyer and seller have, but a lot of the documentation is very similar and the processes are similar. So as a result, the deal documents are somewhere from 70 to 80% standardized and 20 to 30% specialized to a particular industry. Because we are healthcare and because we are highly regulated, our transactions are always a little bit more specialized and a little bit more complex. Okay, so moving right along, important steps in documents. So there's always a process to everything, right? Think of this kind of like a recipe for how you would sell an agency, right? You have to cream your butter and eggs, you have to add your flour, and then you put it in the oven, right? This is sort of the process as well. The first thing is a letter of intent or LOI. Now, this is optional. You don't have to do this, but I think it's a good idea to do it because it helps establish the boundaries of the transaction. And also what it does is it sort of puts a stop to you shopping your agency with somebody else or them purchasing somebody else in your area. That's often the most useful aspect of a letter of intent, to sort of put an exclusivity burden on people. temporarily during the process of the letter of intent, and then you move on to the next step, which is due diligence. And that's where people look at your documentation, your claims records, et cetera, et cetera. The next step is going to be the purchase agreement. And this is the actual document that will conclude the sale. And it's going to have your purchase price and terms, including such things as escrows at any earnouts, representations and warranties, which are very important and we'll touch on a little bit more, any indemnifications, exceptions or limitations to the indemnifications, and then a discussion of ancillary closing documents. So for example, if there's a promissory note or there's anything else that's needed. And then the final step is, again, putting the cake in the oven or going to closing. All right, now, again, I said this earlier, but I'm going to say it again. Before you draft or sign a letter of intent or a purchase agreement, you really do want to discuss this with an attorney. Again, doesn't need to be us. If you have an attorney, more power to you, that's fine as well. But again, these are very complex regulations and you want to make sure that you are not inadvertently violating the law. Federal and sometimes state laws, of course, can impact the terms and timing of a transaction. And so what the attorney can do is help outline limitations in purchase price, financing, notice periods, other key terms. They can help you negotiate some of these things. So here is a perfect example in the last bullet. Sometimes if you have a payout over time, fraud and abuse laws may limit how long the payout period can be. And of course, that also is going to affect things like your purchase price and so on. So again, it's worth it to spend the time and effort talking with an attorney beforehand. Jennifer,
thanks, Heidi.
I think you're up.
Yes, thank you. So as Heidi said earlier, we can't do a presentation without talking about laws. And so as lawyers, we love to talk about, and health lawyers in particular, we love to talk about the Stark Law and the Anti-Kickback Statute. So I'm going to just do a quick rundown on both and how they apply in the transactional environment. The Stark Law actually tends to be less of a concern in healthcare transactions involving home health and hospice, primarily because, first of all, the Stark Law doesn't apply to hospice services, so we really don't need to concern ourselves if we're buying and selling hospice agencies. If we're buying and selling home health agencies, then we do at least ask some initial questions about who owns the target agency that's being purchased. If you have physician investors in a business, then we do need to worry about the Stark Law if it involves home health services. That's fairly uncommon. You don't have a lot of physician investors in home health because there's such restrictions, and essentially, unless they're in a rural area, a physician investor in a home health agency can't ever refer a patient to it. So it's fairly uncommon to actually have to deal with the Stark Law, but I've put a summary of what would be relevant if you did have a physician investor in a home health agency that was being sold. That because home health services are designated health services, if you've got that physician investor, then you do have to worry about how you structure that transaction so that it complies with the Stark Law. Let's go to the next slide. So if that scenario does occur and you've got a physician investor in a home health agency and it's a compliant arrangement and that agency is being sold to a third party, then we do worry about structuring to comply with what's called the isolated transactions exception. I've listed out the highlights of what that exception requires. You must comply with this exception if the Stark Law applies to your transaction. Stark Law is a civil law. The strict liability statute, meaning you must comply or you are in violation of that statute. If you violate that statute, then any claims filed as a result of that violation or subsequent to that violation are effectively immediately overpayments. So it's really important to evaluate early on whether this is going to be an issue for you or not, and structure appropriately if it does, if it is something that you need to be concerned about. Let's go on to the next slide. So the Anti-Kickback Statute is a federal criminal law, which I'm sure you're all familiar with, and as everybody knows, it prohibits the knowing and willful exchange of anything of value to induce or arrange for referrals payable by Medicare or Medicaid. That's paraphrasing, obviously. We do worry about the Anti-Kickback Statute in transactions involving home health and hospice agencies. as I said, because it's a criminal statute, it's fairly complex and it's an intent-based statute. So unfortunately, violations of the Anti-Kickback Statute can carry very significant penalties and obviously potentially jail time. So when we have transactions among parties who refer to each other, where there may be some source of referrals after the transaction closes, we worry about the Anti-Kickback Statute. We worry about valuation of the assets in the transaction itself. So it's really important, and I'll reiterate what Heidi said earlier. You need healthcare counsel when you buy or sell a home health agency. This is not the time to DIY it. The risks you run for violation of these laws are too big, and frankly, the financial risks just associated with the contract, and you want to be able to maximize and realize the value of the deal you negotiated. And when you have some of these regulatory issues that don't get addressed in the context of a transaction, or if you don't have good counsel when you're drafting that purchase agreement to identify and mitigate risks, you can end up losing the value of everything you negotiated. So I'll just reiterate what Heidi said earlier. Hire an attorney to help you, and preferably someone familiar with the healthcare industry. Let's get back to the Anti-Kickback Statute. Heidi, let's go to the next slide and talk a little bit about how we manage compliance with the Anti-Kickback Statute. There really isn't a safe harbor that is specific to buying and selling home health and hospice businesses. Many years ago, the Office of Inspector General with HHS did promulgate a safe harbor that was relevant to the sale of physician practices. And it was intended to protect transactions among practitioners and either from a physician to a physician type of sale, or between practitioners and hospitals. In order to reap the benefit and protection of that safe harbor, you had to comply with every element of it. The good news is, if you don't comply with a safe harbor under the Anti-Kickback Statute, it doesn't mean that you violated the law. It just means that any enforcement authority that ever looked at your deal would look at all the facts and circumstances to determine the party's intent. So that safe harbor, as I said, is really not a perfect fit for home health and hospice. It doesn't technically apply to a home health or hospice transaction, but it can give us very useful guidelines to use when we execute a transaction for a home health or hospice agency. That safe harbor includes things like time limits on completing a transaction, and I don't mean the actual steps of the sale itself, but generally it's the time limits on completing the payment of monies associated with the transaction. And it would also impact on referrals between buyers and sellers after a sale closes. So again, these are complex, and I highly recommend everybody who's looking at a sale of a home health or hospice business or purchasing one, consult with an attorney to make sure you're operating within sort of the guidelines we've been given from the Office of Inspector General to comply with the Anti-Kickback Statute. Let's go to the next slide, please. As I said, if you don't fit precisely in a safe harbor, or there isn't a safe harbor that specifically applies to your scenario, which is the case in home health and hospice, you need to know what those guidelines are, and it often can be helpful to ask the attorney that you consult to help you with your deal for a risk analysis. Have them put down on paper what the transaction looks like, what the risks are associated with it, and what the parties are doing to mitigate those risks. That's a great thing to have in your file should anybody ever come back and look at your transaction and question it. As Heidi mentioned earlier, it often can be also very valuable to have a valuation expert or appraiser provide an opinion on the fair market value of the transaction price. This is an extra step. It sounds like an unnecessary expense, and I have lots of people ask me, why are we bothering to do this? There's a and it isn't every deal where you need this. It's very fact specific, frankly, but it can be an excellent defense tool, essentially, if you do have parties that may have some ongoing relationship or there's some question about the fair market value of the deal, to have an opinion from an outside expert that supports that the price paid and the terms of that payment represent fair market value and are commercially reasonable. So let's go to the next slide. So as Heidi mentioned, letters of intent are optional, but I would say 99 times out of 100 in transactions I work on, there is a letter of intent. Sometimes I get involved in the negotiation and drafting of that letter of intent. Sometimes the deals are brought to me after that letter of intent has already been negotiated and signed. I prefer to be involved before you sign it, simply because business parties will put things down in a letter of intent that make lots of sense to them, and buyers kind of understand their purpose. But if I'm representing sellers who probably or maybe have never sold a business before, it's important that they understand what's being documented in that letter of intent, what the purpose is of it, what's enforceable, what's not enforceable. But sort of more holistically, a letter of intent sets down the most important terms of your upcoming transaction. It isn't, this is what we think we might do or we guess we might do. It really is, it sets the tone for the deal. And it certainly, buyers will say, well, that's what we wrote in the letter of intent, so that's what we expect. So I often like to encourage sellers, listen, let's look at the letter of intent together. Let's talk it through. Let's be sure everybody's comfortable that these terms are reasonable, and what is the expectation if something were to change, or if you're not entirely comfortable with what's in it at this point. Don't expect that you're going to be able to come back 30 or 60 days later and say, I'm not happy with those terms, I want to change them. It sets parties' expectations, and so it's important that when you do that letter of intent, that you're fairly comfortable with what's there, and understand that the only things that are really binding in a letter of intent are generally the confidentiality, non-disclosure provisions, and the exclusivity. So that being said, letters of intent are important. They help the parties all get on the same page, and they often set up a timeline for actually getting from the letter of intent to the purchase agreement to a closing. So it's an important document, and I would say more often than not, the vast majority of the time, most of the deals I work on, we have a letter of intent. Heidi, I think I'm going to turn it back over to you, and you're going to talk about due diligence.
Yes, thank you, Jennifer. All right, so this is probably one of the most important steps in the process. This is due diligence, and the maxim that applies is caveat emptor, which I'm sure you've all heard of, means buyer beware. And so what happens is the buying party, both parties, but particularly the buyer, will conduct due diligence. And the purpose of this is to make sure that they're purchasing what they think they are purchasing. So as a result, they're going to do things like request copies of and review financial statements, tax returns. They're going to review the business operations, maybe your locations. They want copies of licenses, certifications. They're going to ask you about audits. They may show up in person to kind of take a look at the place. This is a very, very important step, and it should not be taken lightly. And even though the bulk of the due diligence happens by the buyers looking at you, if you're the seller, you also want to do some due diligence, because typically many transactions involve some kind of earnout or payout of the purchase price. They're not just going to hand you cash, or some of it is going to go into escrow. And so you want to make sure that who you are selling your business to and who is going to be paying you is financially stable. Likewise, a lot of times the owners of an agency will enter into an employment relationship with the purchaser, particularly if it is a bigger, larger organization, private venture, or a national chain. So you're going to become an employee then for this company. This is like going through the hiring process. Then you need to make sure that you understand who these people are and that they are not fly-by-night operators. Probably not, but you want to do your due diligence. And there may be things that you run across in the process of the due diligence where you kind of go, oh my gosh, I don't think I can live with this. And then you're going to have to think about, if you're selling your agency, as I said, are you going to have some kind of continuing role in the agency? So you want to make sure that you do your due diligence and you cooperate with the purchasers in doing their due diligence. Failure to cooperate in due diligence is often a key reason why a deal goes south, because the purchasers are expecting you to behave properly and promptly in doing this. And if you can't provide documentation in response to due diligence requests, then it calls into question your sort of entire management of the agency. So think about that when you get due diligence. We do have some special concerns in relation to healthcare. You want to do a mini claims audit if you haven't gotten one. If the purchaser keeps the provider numbers, they're going to get all of your Medicare and Medicaid liabilities as the successor in interest. And so they're going to be very concerned that your claims and your documentation to support those claims are acceptable. So get a jump on it, do an audit yourself ahead of time, and make sure that your claims documentation is good. And if you have had audits by payers, you may want to go back and see what the status of all of those is. Again, as I said earlier, a lot of the audits sort of paused during the public health emergency. I had a case just recently where somebody wanted to sell an agency. They did sell the agency. They had had an audit by one of the payers about 2 years, 18 months to 2 years prior to the actual closing, and never heard anything more from the payer after the audit. So they assumed everything was A-okay. Well, they went through closing, and about 5 weeks after closing, the payer sent a letter saying, "We finally completed the audit and you owe us fill in the blank amount of money, significant amount of money," which of course made everybody very upset because they had represented to the purchasers that there were no outstanding liabilities and there were no outstanding claims. And, you know, the purchasers were, you know, going, what gives? Did you lie to us? So make sure you've done your audits and follow up on any outstanding audits. Engage an outside expert if necessary. And again, what you want to do is you want to identify all the weaknesses in medical records and documents supporting the claims. If you're far enough out from actually selling your agency, you have an opportunity to fix these, you know, by getting additional supporting documentation. You also want to know what is out there, because again, if you have any big problems, that's going to greatly reduce your purchase price, or the buyer is going to ask for a large escrow because they don't want to be on the hook for a large overpayment and refund to a payer. In some cases, big problems will kill a deal entirely. Both Jennifer and I have seen that. So again, make sure you go through your claims records and your patient documentation.
Thanks, Heidi. So we're going to talk a little bit more specifically now about purchase agreements, what those look like, and the structures, the prevailing structures, the most common structures for purchases. A purchase agreement in and of itself is a fairly standard document. There are form documents that have been created by different legal associations that are commonly used in the industry. The American Bar Association has forms that we see very commonly, but every law firm probably has certain tweaks and things they've changed to customize transactional documents to a format that they're comfortable with. So when you're in the midst of, if you're a seller, generally speaking, the buyer is going to draft that purchase agreement, and if you're a buyer, you're going to have retained counsel to help you with the deal, and your attorney is going to be responsible for putting down on paper all of the terms of the deal. This is your definitive agreement for the transaction, and it's going to set out price, risk allocation, and all the other material provisions of the transaction. It's going to set all the terms for payment, closing, penalties, liability exposure, dispute resolution, everything and anything associated with this business relationship that you're entering into. So it's incredibly important that it's negotiated and documented and reviewed very carefully by both sides of the deal. It's important that you don't leave, if there are provisions within the purchase document that as a seller, you don't understand or you're not comfortable with, it's very important that you, talk to your counsel. Sellers shouldn't go unrepresented into these deals. Don't sign documents that you haven't had counsel review, and if you have questions, that all your questions have been answered, because once it's down on paper and the parties sign it, this reflects and will serve as the basis for mediating any dispute after the fact. I don't want to bore you with a long-winded discussion of the four corners of the contract controlling the relationship between the parties, that is absolutely true. So it's important that that document is an accurate representation of what buyer and seller have agreed to. So let's go to the next page. There are three different typical forms for a transaction. The first is an asset sale, the second is an equity sale, and the last is a merger. We're going to talk mostly about number one and number two, asset sales and equity sales, as those are the most common form of sale for home health and hospice businesses, and generally for healthcare businesses. That's what we typically see. Mergers are much less common and typically happen between very large companies. In an asset sale, the buyer is acquiring certain identified either hard assets or in what we call intangibles. And generally in a home health and hospice deal, the biggest asset being purchased is the goodwill associated with the business. That's sort of your ongoing, what we will call the going concern. So the asset sale will identify all of the things, and I put that in quote, that the buyer is buying. And if you want to think about this from a before and after perspective, before the sale, you know, it's ABC Home Health Agency is selling the assets of his business, and after the sale, an entirely new company with a new tax ID number, new legal entity owns those assets. So there are certain contracts, and there are certain, as we said, Medicare and Medicaid provider agreements that may be transferred as part of that sale, but when it's over, a brand new company owns all those things. In an equity sale, the buyer is buying the seller's equity in the existing business. Before and after the sale, the same legal entity will own that business that owned it, you know, before and after, the same owner, same tax ID number exists. So the difference is important, because in an asset sale, you have an opportunity to, what I would basically say is shed some liabilities. So the buyer can, to a certain extent, pick and choose whether it takes on certain liabilities or not by sort of rejecting either certain contracts or certain things it doesn't want because the seller entity may have some problem it's having to deal with or some liability that the buyer doesn't want to mess with. In an equity sale, unless it comes through as a completely debt-free, completely clean entity, that buyer's getting every problem that seller entity has. So if there's a tax liability or a piece of litigation or something that's hanging out there before the sale happens, unless those are fully resolved before the sale is closed, then the buyer is taking those on because they're going to own the company and all its problems after closing. So I would say right now, in the last, let's say 18 months, I'm seeing a pretty equal 50-50 split between asset sales and equity sales. I would, if you'd asked me this question 18 months ago, I saw a lot more equity sales. Interestingly enough, buyers are a bit more conservative these days. I don't know if that's just the nature of the deals I've been looking at, or the buyers. I've been representing sellers almost exclusively the last 18 to 24 months. COVID really brought on a huge rash of smaller owners and smaller companies selling out to larger companies. And many of those deals are asset deals now. But I do see equity deals still. And as I said, it's about 50-50. Let's go to the next slide. There are unique healthcare issues in all of these transactions, as we've said before. In an asset sale, there aren't a lot of things, tangible things that home health and hospice companies own. They own, you know, office equipment. They own IT equipment sometimes. Sometimes they own vehicles. More often, they lease them. That's a whole other issue. But they don't have a lot. They generally don't own real estate. They generally don't own big, expensive equipment. So their biggest asset is goodwill. Generally, buyers do want to take assignment of Medicare and Medicaid billing numbers. When they do that, they take on the risk of any liabilities, but through the transactional document, they're going to push that risk back to the seller contractually. So asset deals are more common when you've got non-healthcare debts associated, like tax debts or vendor liabilities. You owe third parties money. Or where a buyer doesn't want Medicare or Medicaid numbers, but I see them in more and more instances now. I'm seeing them in what I would consider to be fairly typical home health and hospice deals that don't necessarily have these problems. And some of that is just conservative buyers that even though they've turned over every rock, they're still reluctant to do an equity purchase and take on what they may perceive as unknown liabilities associated with that company. So that's sort of what's been driving it lately, just the unknowns in healthcare. And as you might imagine, being in this business, there are lots of those. So stock, membership interest sales, equity sales, as I said before, the actual legal entity that owns the business doesn't change, only the shareholders or members do. It's a much simpler process from a regulatory perspective and from a contractual perspective. And when I say that, I mean in an equity sale, generally speaking, there are a lot fewer consents and other things you have to go get in advance of closing that transaction in order to allow all of the contracts that support that agency. So let's say your staffing contracts, your payer agreements, your vendor agreements, all of those generally will just continue on as though nothing has happened when an equity sale happens. In an asset sale, oftentimes, all those contracts, you have to notify all the people that agency, that selling agency contracts with and say, hey, we're selling assets. The buyer would like to take assignment of your contract, but we need your permission to do that. So asset sales, for that reason, can take longer to close because you have to go through these consent processes. In Texas, it also requires a licensing application to be filed, and depending on whether or not your agency provides waiver services through a contract with Medicaid, it can require filing of applications related to that do extend the timeline for an asset deal. That's, again, the parties often discuss a form of transaction very early on in the letter of intent stage. Sometimes that changes as due diligence gets done. It's just a matter of sort of how things develop over time. But these are just some go-bys to give you an idea of the difference between the different forms of transaction. Let's go to the next slide. Purchase price structure. So I told Heidi I wanted to cover this because I've seen sort of so many different variations on how buyers want to structure purchase prices these days. And I am seeing some themes. So buyers generally want to pay a portion of purchase price at closing and then hold something back to cover potential liabilities over a period of time. And it kind of depends on the buyer. It depends on whether this is an owner finance deal or not. I'm seeing fewer and fewer of those, by the way. What I am seeing are venture capital and private equity backed deals where the buyers are, they've got investors behind the scenes. And in those deals, they tend to be sort of pretty, I want to say standardized, but I'm seeing themes, let's put it that way. So in those types of deals, what we're seeing is a purchase price often based on EBITDA, some multiple of EBITDA, and they want to pay somewhere generally between 90 to 75% of the total purchase price will get paid at closing, and then 10 to 25% is being held back in an escrow fund for a period of time. And that can range from somewhere between 12 and 36 months. That can be very, very fact specific. It really depends on the seller agency and the potential liabilities that the buyer sees associated with that seller agency. I would say they probably, if I had to kind of say what's most common, it's usually somewhere between 12 and 18 months. Obviously, if I'm representing a seller, I want that to be shorter, and I want the holdback percentage to be lower. Those are often terms we negotiate even at the letter of intent stage. Sometimes we can't be very specific or precise, and buyers don't want to be too specific or too precise at the letter of intent stage. But this gets hammered out in very fine detail once you get to the purchase agreement stage. And sometimes you need to do some due diligence before you can really fully agree on what a holdback will be and how long it will be held. I will say this, in smaller deals I've worked on with less sophisticated buyers, oftentimes they come in and they're like, well, we agreed they're going to give me 75% of the money up front, and then they're going to pay the rest of the 25% in 3 payments over the next year or 2 years, and we're all good. And I sort of sit down with my client, whoever that might be, if it's buyer or seller, and say, okay, let's sort of think about how do we ensure, if I'm representing a seller, How do I ensure you get paid? And how do I give you some legal recourse if you don't get paid? When you're dealing with large post-closing payments, there's two specific ways this generally happens. One, either you do a formal escrow where the buyer has to put any holdback into an account subject to an escrow agreement with a third party who's going to sort of manage that account and is going to pay out money pursuant to some terms that have been put out in writing between the parties. And it's going to say, we're going to hold 10% of the purchase price for 12 months, and when certain conditions are met, that money gets paid out by the escrow agent. That is a very common arrangement, and it protects the seller because that money is there. You're not having to question or worry whether that money is going to be available when it's time for you to get paid. The other nice thing about it is that for buyers, it means that if a liability were to come up while that money is in escrow, they want to build into the purchase agreement that they can deduct that liability from the escrow account. And again, very common in purchase transactions like this. The other common structure I see is, especially in owner finance deals, you'll see a buyer pay some portion of the purchase price up front, and that can vary all over the place. As a seller representative, I want them to pay as much as I can get them to pay at the beginning. And then they'll sign a promissory note for the remaining amount of the purchase price to pay it out over some period of time. Usually there's interest, and promissory notes, especially, in owner finance deals, you've always got risk. You've always got risk that something's going to happen and that buyer's not going to be able to pay you. So generally we want those to be secured with the assets of the business. And so if a buyer doesn't pay you and something happens, you can take the agency back. There's a lot of risk in that scenario because, I've seen some things happen over the years of, 20 plus years of doing this, and I've certainly seen some sellers who got stiffed. So it's important when you're thinking about these sale terms that you consult with people who have experience in these types of transactions to help advise you on sort of what is normal in the industry, what is sort of typical, what are typical terms, and how do we protect the seller and the buyer in these when we structure these purchase prices. Another thing to keep in mind, which often surprises sellers, is there are always purchase price adjustments at closing. Those can be to satisfy a debt that needs to get paid before the deal closes. Those can be to pay transaction costs of either a broker or your legal counsel that gets deducted from those closing funds. Or it could be to provide working capital for the buyer. So generally speaking, buyers are going to want the agency to have enough cash on hand or enough accounts receivable on hand to cover expenses to operate the business for some period of time. Usually it's a month or so. That's called working capital. And generally there's some kind of analysis done close to closing about how much accounts receivable are sitting out there, how much cash is in company bank accounts, and then they look at what are the costs going to be over the next 30 days for things like payroll and vendors. And if those numbers don't balance out, there can be an adjustment at closing. It can either favor the seller or the buyer. So just be aware there are often purchase price adjustments built into these purchase price structures when you start, putting this stuff down on paper. So Heidi, you're going to talk about reps and warranties. I know we're running out of time, guys, but bear with us. We're happy to keep talking if you're happy to keep listening.
Yep. So one of the things that is going to be in a purchase agreement is something called representations and warranties, or, the attorneys short it to reps and warranties. And basically these are promises made by both the buyers and the sellers. And it's a promise that certain statements or conditions are true. And your reps and warranties are going to be specific to every transaction. There's, again, as Jennifer said, some themes about certain things, but you may have some very specific reps and warranties in your purchase agreement. And in your disclosure set schedules that are attached to the purchase agreement, you may have specific exceptions or facts that tie back to your reps and warranties. These are important because if you make a rep and warranty saying something is true and it's not true, so it's a material inaccuracy, then the buyer can sue for certain amounts, possibly, get indemnification for things that are not true. So common reps and warranties that we see are a statement that the financial reports are accurate and complete. And again, if you've had an accountant or a CPA doing that, that should be fine. Another common rep or warranty is that no litigations or audits are pending. So I mentioned this scenario that I had with a client just this past couple of months, where they thought the payer audit was done with because they never heard back from them. So they actually had a representation that there were no audits and they owed no money to a payer. Well, when the payer came back 5 weeks after closing to say, guess what, you owe us this money, now they were in potential violation of that rep and warranty. And it's something that the buyers sort of sat up and took notice about and were very, very concerned about. Another common rep and warranty is that you've complied with all applicable law. And again, since this is a highly regulated space, you want to make sure that there is no reason to find that you have in fact violated the law, because again, somebody could be in serious trouble. We have usually specific reps and warranties in a healthcare transaction and for a home health and agent or hospice agency. So here are some of the specific listings, so that you have all licenses, certifications, and contracts necessary to operate, and that they're current and good standing. Again, if you don't have a license, what's the point of purchasing the agency? Again, many purchasers are looking for a certain population base. They want, certain Medicare or Medicaid patients. So they're going to make sure that you're enrolled in Medicare and Medicaid, and those enrollments are active and in good standing. This is important as well, even if you don't do Medicare or Medicaid, because a lot of private insurers require that you be enrolled in Medicare or Medicaid as a prerequisite for being in the payer's network or receiving payments from that payer. Another rep and warranty is that there are no disciplinary or corrective actions or appeals outstanding. So for example, if you have nursing staff, obviously this is going to be very important for nursing staff, that there are no disciplinary actions relating to your nursing staff. That the seller has been conducting exclusion screening, has records of it, and there are no employees, contractors, vendors, or owners excluded. This is a huge one because obviously if you have been excluded and they purchase the assets from somebody who has been excluded, the purchaser themselves risk being excluded as well. It's sort of this blacklist, spreading blacklist. So they're going to be very, very interested in that, and that's going to be a topic of due diligence. Again, there's going to be a rep and warranty that there are no claims, enforcement, or other actions, administrating procedures, audits, or investigations pending. And again, as I said in my prior story, this was where we had the issue here. In home health deals as well, you also must make a rep and warranty addressing the 36-month rule. So you actually need to be considering whether or not you've had any changes in majority ownership in the last 36 months, and this will be one of the reps and warranties that you will sign on to in a purchase agreement. Another important thing is indemnification. So again, this is what happens if something goes south or something crops up. Who's going to pay for and be liable for this? Indemnification actually protects the purchaser, and again, purchasers will typically have some pretty strong indemnification language. And basically, the seller agrees to compensate and hold harmless the buyer for any problems that arise that were the result of the seller's actions or behaviors prior to the date of sale or breaches of their reps or warranties. So as the example that I gave, again, if let's say you have, as Jennifer said, a stock purchase, and so you've purchased the agency and now you come back with a payer requesting an audit, well, the agency is going to have to pay, if there's a refund, have to pay that back, but then the purchasers are going to turn back to the sellers and want indemnification for the amount of any of that refund. So again, because of these issues, it's very, very common to see an escrow of a portion of the purchase price to cover this. And again, this is protection for the seller as well, more for the buyer, but there can be reasons for the seller to have indemnification as well. Another thing are what are called qualifications or exceptions, and these are anything that limits a party's liability. So you can have, for example, a cap on the amount of the liability, or revision of certain reps or warranties, and so on. One of the most common ones that we see is a materiality qualification. So basically, if the dollar amount is material to the business, then you want to have obviously a whole lot of indemnification. But let's say one of your aides was out there and got a parking ticket. Now, technically, that's a liability. But really, is the buyer going to come back and ask you to pay for the parking ticket that should have been paid for the aid? That may not be a good example, but that gives you an example. A parking ticket is not material to the transaction, and so that might be something that you don't want to have in there, and you want to put in a materiality requirement that if you're going to indemnify the purchaser, it has to be for a material amount. You also may want time limits. And again, you don't want this indemnification to last forever. And so one of the things that we look at are the statutes of limitations on healthcare laws. How far can a payer go back and audit? And that may be a time limit on an indemnification. So these qualifications and exceptions can be very much negotiable. They're very fact specific and will often arise as a result of the due diligence. But be aware that they are out there, and these things do crop up and show up in asset purchase agreements. Jennifer.
Thanks, Heidi. So you've got your purchase agreement all negotiated, and now you want to think about, okay, how do we close this transaction? Healthcare deals tend to follow a timeline that everybody should be familiar with. If you've ever bought a house, you sign a contract for sale, and then 30 or 60 days later, you close on your transaction. Healthcare transactions tend to be very similar. We generally sign a purchase agreement early. Then there are some filings and other conditions that have to be satisfied before you can actually close the transaction. So it isn't unheard of to close a transaction the same day you sign the purchase agreement if a deal structured and notice provisions will allow that, but it's fairly uncommon. In Texas, if you're doing an asset transaction, you're absolutely going to have to sign and then delay closing a minimum of 30 days generally, because in a true change of ownership, as that term is defined in Texas law, that's basically where the buyer is going to own the assets under a different legal entity with a different tax ID number. That's a true chow. That requires a minimum 30-day advance notice and filing of a new license application with Texas Health and Human Services. If the selling entity has a waiver contract with Medicaid, then generally and there's some complicated rules about when this 60-day advance notice applies, but it always applies in an asset sale, and it sometimes applies in equity deals. If the rule does apply and it is considered a change of ownership under the Medicaid rules, then it's a minimum 60-day advance notice and application for a new waiver contract. So it's very, very common to have a signing of your purchase agreement and then a closing that is delayed for 30 or 60 days. In that intervening period, after you sign, before you close, there's going to be a list of what we call conditions to closing that have to be satisfied. And these are things that have to get done between the time you sign and the time you close in order for the buyer to agree to close the deal and pay you money if you're a seller. So if you can't meet one of those conditions, then it's grounds for the buyer to call the deal off. And it can cut both ways. It can also, there could be conditions to closing for buyers, for example, things like securing financing that can allow a seller to bail on a deal if the buyer's financing doesn't come through. So oftentimes these conditions to closing can be pretty lengthy, depends on the transaction, but it can be anything from a buyer renegotiating a lease for property post-closing. It could be filing a licensing application. It can be securing certain key employees to employment agreements for post-closing services. There are any number of conditions that might be important to a buyer and a seller that fall into this conditions to closing that have to get done. And And they almost always in asset deals involve vendor and third-party payer consents coming through. So again, very common for us to see signing with lots of conditions to closing and a closing that happens 30 or 60 days after you sign. Let's go to the next slide. At closing, hopefully all the parties have reviewed all the documents that are going to be signed at closing, and everyone's comfortable with the status of those. There's often some standard documents that get signed at closing depending on the kind of deal. If it's an asset deal, generally you've got some kind of bill of sale for the assets and also some kind of assignment agreement for key contracts that are being assumed by the buyer. In an equity deal, you've got an assignment of that equity interest, and there can be some related documents like non-compete agreements or restrictive covenant agreements. There could be financing documents, and there may be an escrow agreement if you're escrowing a portion of the purchase funds. And there are a whole host of other things that might go along with that, that include things like updated disclosure schedules and resolutions by the buyers and sellers, governing bodies to approve the transaction closing, things like that. Lots and lots of details that both parties are going to be worrying about leading up to closing, and I cannot stress how important I think it is that buyers and sellers are well represented by counsel, so that when you get to that closing, you're ready to sign, and everybody's able to walk away feeling satisfied and comfortable with where they are. Obviously, if all those documents look good and you sign on the dotted line, then purchase funds are transferred from the buyer to the seller, and any escrowed monies are deposited with the escrow agent. Let's go to the next slide. So after,
go ahead.
Heidi, I think you're going to pick up from here.
Yeah, no worries. So like baking a cake, just because you take the cake out of the oven, it isn't done. Signing and closing is like taking the cake out of the oven. There's still things that need to happen after the closing. And so your relationship with the purchaser or between the buyer and the seller rarely ends right at closing. Many buyers actually want a transition period, so the seller will stay on for some period to assist in retaining employees, patients, making a transition to a referral sources, smoothing that over. And the seller's personnel can either do this pursuant to an employment agreement if it's longer, or sometimes just, stick around for 60 days type thing. But again, the goal of the seller is to really minimize its exposure to liabilities from claims made by the buyer. Now, the buyer, of course, is now running the business, and they want to make sure that they have an operating business and that they're, in a space to file claims and seek a profit. So if there are issues that arise here, for example, the seller is not paying payments pursuant to a promissory note or is not doing something else, the buyer then may have legal recourse at this point. And again, a lot of transactions have deferred payments, either, a payout pursuant to a promissory note or escrow agreements or something like that. Sometimes there's an earn-out, that claims were filed, and you get some portion of accounts receivable as a seller. So you're really going to need to rely on each other to comply with your various payment obligations. And of course, you want to make sure that everybody is appropriately documenting and doing what they need to do in order to support those payouts. Another thing is that many transactions include restrictive covenants. There are some that protect the buyer, such as the non-compete or non-solicitation covenants, and there are some that protect the seller. And those would be, covenants like, taking on the business's employees, pay and severance, making sure employees are properly terminated, and so on. A lot of these restrictive covenants, non-competes in particular and non-solicitation, are the subject of disputes and can be very expensive to litigate. So you want to make sure that any of these covenants have been reviewed by an attorney. There are specific requirements, for example, for non-compete agreements. they have to be limited in their scope by what is called geography, time, and practice area. And that's going to vary depending on any particular transaction. So you want to make sure that the non-competes, if you're the seller, that the non-compete is not too extensive. And if you're the buyer, you obviously want to make it as extensive as possible. In addition, if you're doing an asset purchase, you may have contracts that must be assigned and transferred. So as Jennifer mentioned, there are things like leases. You may want to have your medical directorships transferred and assigned, and sometimes EHRs are assigned as well. Again, we often have post-closing price adjustments based on updated valuations or accounts receivable splits, straddle periods, right? Because you don't get a fee for service type thing. You're covering a range of dates in terms of dates of service. So, you know, let's say you have a patient who is 45 days into a 60-day episode and you get the payment at the end. How do you value that? So what you're going to need to do in your purchase agreement is define how that accounts receivable is going to be split. And this is a lot of the negotiation that happens. And if you don't handle it up front, obviously, as you can tell, it's going to be a big source of dispute and contention and potential liability after the fact. So you want to really understand how your AR is going to be split. The buyers often also want purchase price adjustments because, again, if you are getting some kind of a payout pursuant to a promissory note, or you have you know, other conditions to that, you want to make sure that the buyer doesn't let the purchase price fall apart. The business fall apart during the transaction or shortly after the transaction. You know, maybe not going to ascribe motives to sellers, but obviously if the revenue coming in is not what the buyer said it was going to be, then the seller has a reason to either ratchet down the purchase price or, you know, perhaps engage in litigation. So there are things that you want to make sure you understand about that. And of course, you have to file your Medicare and Medicaid change of information or change of ownership applicants timely. Remember, you only have 30 days after closing to do that. And of course, you're going to need to depend on each other to get those done promptly and properly and with the correct information. Jennifer.
Thank you, Heidi. So as we mentioned earlier, licensing requirements can often drive transaction timelines and asset sales. For a license application, ideally, there is a regulatory requirement that says you have to file 30 days in advance. You have to actually file the licensing application. That's done by the buyer. That timeline, you can pay penalties, and there's basically a late fee you can pay on the licensing application. Let's say if you file, 20 days or 15 days before you close. But what you absolutely 100% cannot do is not file that license application before you close the transaction. HHSC has actually pulled licenses where people have done an asset sale and didn't tell them about it. That's a big no-no in Texas. So even if you're running up against, the 30-day timeline, get with your healthcare counsel to help you get this process finished before you close that deal. In an equity transaction, there's generally no advance notice required to HHSC. Again, there may be Medicaid things we have to worry about, but you do have notices to file after closing in an equity transaction with HHSC, and you have a fairly short time to do that. It's either 5 or 7 days. I'd have to look at it, but you do that through TULIP, and you update your ownership information. In either an asset or equity deal, if you've got things like primary home care, family care, or community attendant service waiver contracts, it is very important that you file those applications a minimum of 60 days before closing, or you can lose your contract, and the buyer won't have the benefit of that. So if that's something that's important to the transaction, the timeline really needs to be planned out carefully. Heidi alluded to a representation and warranty about the 36-month rule in home health transactions. It still has a tremendous influence on home health deals these days. Often buyers will, if this is an issue and for whatever reason a home health agency is trying to sell its business and it's been less than 36 months since its last change in majority ownership or since it was initially certified, buyers and sellers can work together on how to sort of manage that timeline. And I've seen parties agree to just wait. I've seen parties agree to sign a purchase agreement and have the buyer come in and manage the business for, generally it's a fairly short amount of time until a 36-month timeline runs out. I don't often see those being, more than 6 months, but it really just depends on the parties and how comfortable everybody is with whatever terms they can come to on that. If you're going to do a sign and manage while a 36-month period runs out, it's, I think, really important to have an attorney help you draft that management agreement that all the parties are going to follow during that sort of interim period and build it into the transaction. I've seen these. I did one last year where this was an issue. I have one sitting on my desk right now where this is an issue. So they're common. It can be dealt with. It can be structured around. But it's really, really important, if this is a potential issue in your transaction, that you think it through, that you get good advice on when that 36-month period runs out. There are a couple of exceptions that can sometimes help the parties shorten that time frame. Because if you don't follow it and you're not aware of it and a buyer buys the business and there's a 36-month rule problem, HHS will take away the provider agreement. It will be terminated as of your closing date, and you won't have a Medicare number. So that can be just a devastating result. And I've actually had that happen in a couple scenarios, not for several years. And we've had to try to, very quickly go and unwind transactions to try to fix that problem. But I cannot guarantee anybody that it can be fixed these days. So it is something in home health transactions, especially, that you have to be aware of. Let's go to the next slide. It's really important when you're working on a transaction that you review things like payer contract assignment provisions. Payer contracts, especially in an asset deal, will almost always have language that says you can't assign this contract to a buyer of your company or to a third party unless you get the payer's permission to do that. And permission means in writing in advance of closing the transaction or in advance of assigning the contract. Those can take some time, and so it can affect the timeline for your transaction. And it's important early on in the due diligence process for the seller and the buyer to develop a good working list of the contracts that the seller agency has and which of those the buyer wants to keep. And then you need to systematically go through and work on getting those contracts assigned if there are provisions in those contracts that require consent. So sometimes you have what we call change of control provisions that will require consent even in equity deals. I see those a lot less commonly, but they do happen. So it's important when you're working with counsel, both on the buyer and the seller side through that due diligence period, that you identify those contracts that are really important to the business and you think this through in advance so that you can get these tasks accomplished and get the deal to closing. Always, always, always important to retain staff. These are, ultimately home health and hospice deals are, services rely on the relationships between patients and staff. And it's very, very important to the patients that they see continuity. If you're going to retain patients, you're going to want continuity in staff that sees those patients every day. So retention of staff is always a big, big deal in these transactions. Don't forget about your accreditation. If you're an accredited agency, then notifications have to be sent to the accrediting body about the sale, and there may be paperwork that needs to be filed. It's generally not terribly complicated paperwork, but it does need to get done. Buyers, as part of the due diligence process, should absolutely review a seller's compliance plan, policies, and procedures, and any audits that have already been conducted or that might be pending. Buyers generally, big sophisticated buyers that are private equity-backed companies or large organizations generally have a process, and they'll have consultants that are helping them with due diligence. When a small buyer buys a small seller, it can be a little less formal. And I tell those parties, it doesn't mean you shouldn't be doing these kinds of things. It just means we need to scale them to the size of the transaction. And counsel can help with that. They can help the buyers with that, and they can help the sellers with that. We can put you in contact with consultants and perhaps even do some of that review in-house. But just because you're, a smaller company or a seller or a smaller buyer doesn't mean you shouldn't be doing this due diligence and looking at these kinds of issues. Obviously, buyers are always looking to maximize the value of what they buy, and they're going to consider what kind of cost-saving strategies that can be realized in a transaction as they merge, an acquired asset or acquired company into their existing business. They're going to be looking to remove redundancies, streamline technical and administrative systems, and look at outreach and marketing efforts. It's really, there are lots and lots and lots of pieces to these puzzles when we start talking about transactions. And I've been on both sides of deals, been doing a lot more seller work of late. And, there's an early conversation. Buyers are always looking at, why is this target of interest to me? What am I looking to accomplish by buying it? How am I going to most effectively, blend this into an existing business if the buyer has one? And maximize my opportunity to be successful. So that's an important, analysis for the buyer. Same, likewise for the seller. Buyers are often looking at what changes can they make to that seller business to reduce costs. That can have a really important and sometimes negative impact on the seller, because if a buyer comes in and says, listen, I love your agency, you've got great staff, but I don't want your EMR, and I don't want your vendor contract, and I don't want your copier contract, and I don't want your this, that, or the other. The seller's going to be stuck with those, trying to figure out how to deal with them, and often they have really, really bad termination provisions in them that leave the seller stuck with a lot of post-closing liability. So it's important in these home health and hospice deals that, if I'm representing a seller, we're going to talk about all that in advance. We're going to think it through, and we're going to look at the purchase price and make sure that at the end of the day, sort of the net is the money that you're going to end up with at the end of the day after all these liabilities are gone is what you think it is. Let's just put it that way. Let's go to the next slide. So I think it goes without saying that transactions can be very complex. They can take some time. I don't think it's unusual at all for you to think about a 90 to 120-day process from beginning to end. Sometimes it's shorter, sometimes it's longer. I've had deals drag on for 9 months. Those are not necessarily in Texas. Our regulatory process here tends to be much simpler than in some states back east where you've got things like certificates of need to deal with. But obviously they can be, tremendous for both sellers and buyers if you've done your homework and you've, crafted a well structured purchase agreement on terms everybody's happy with. You obviously need to take into consideration things like fraud and abuse issues when you're structuring those transactions. And I know we've said it before, but I'll say it again. You really do need experienced professionals helping you through this transaction process, whether you're a buyer or a seller. And that may include lawyers, that may include things like valuation experts and appraisers, it may include clinical experts who do due diligence review for you. It could include accountants who are helping clean up your financial statements, make sure they're in good shape. And from the buyer's side, evaluating the seller's financial statements and making sure they're accurate and industry standard. We always worry about long-term risk allocation issues. Those are those indemnification provisions that, hold one party or the other responsible for liabilities based on when they occurred and what they're related to. It's really important for a lawyer representing a seller and a buyer to get to know those organizations well and to understand what the risks are in both the seller organization and the buyer organization. So that being said, I think we're done. Heidi and I are delighted you joined us. I know we ran very long. We started late. Our apologies for that. But if you have questions or you ever want to talk to one of us, our contact information is here on this last slide.
All right. Thank you, Jennifer and Heidi. That was a great presentation. And thank you to our attendees for sticking with us here. Everyone from today's webinar will receive copies of the presentation slides, and that concludes today's webinar. Let me check if there's any questions first. Ooh, Can I read a couple questions out loud before we close up here?
Sure.
Sure. Yeah.
All right. Is a chow required for a stock purchase since the tax ID stays the same?
So it depends on what you're asking. There are certain regulatory filings that would still have to be filed with both the state and with Medicare or Medicaid for a stock purchase. Generally speaking, we don't call a stock purchase a chow. That doesn't meet Medicare's definition of a chow, what we call a change of ownership. That being said, there are some Medicaid rules and things that word might be brought up in an equity sale, but generally speaking, you're not entering into a true change of ownership for Medicare purposes or for licensing purposes in Texas when you have an equity sale. That doesn't mean you don't have things to file. It just means they're generally not filed in advance of closing.
Okay, I have one more question here. When will wrap suppression be effective if we sell our agency? At the time of submission of a 855A to CMS or submission of CHOW to HHS in Texas? Can you please clarify?
It's going to be when Palmetto becomes aware of the transaction.
Okay. Looks like those are the two questions that people posted. So that does conclude today's webinar. Thank you all and have a great rest of your day.
Thank you.
Thanks all. Bye.